Head to Knoxville, don't be late. Baker's Live, it's gonna be great. June 5th and 6th, mark your date at Dollywood, we'll celebrate. Meet Baker and more cool friends. Live show magic that never ends. Come to Dollywood, feel the vibe. With great people there, it's gonna be a ride. Rides, fun, and meet and greet. Baker and pals, the crew's so sweet. Get ready for laughs, cheers, and thrills. Knoxville's the place, it's giving chills. Meet Baker and more cool friends. Live show magic that never ends. Come to Dollywood, feel the vibe. With great people there, it's gonna be a ride. June 5th and 6th, don't miss the fun. Meet Baker and friends, it's second to none. Baker and friends, it's second to none.
Good morning, good evening, good afternoon, wherever you are, whoever you are, and whatever you might be. Welcome, Valhalla.
Hey, how we doing, guys?
We'll ask you the same.
Are you a new goat
sweating.
daddy?
Not yet. This goat's still being a pain in the butt, but we're giving her all the time in the world that she needs, and hopefully we just get a healthy baby goat out of the deal when it's all said and done.
Can you get closer to your microphone?
Yeah, I sure can. My apologies. Hi, Andrea. How are you doing?
Hey, Val. things are good here.
Good. That's what I like to hear.
I will warn you, I might have a little bit of noise because I've got the old dog in here with me tonight. We got some bad news about the old dog this last week. He's old. He's 13. It's pretty old for Vizsla, but he's got cancer. So we're getting our last, good times that we can have with him. And so I'm not booting him out of the office when I go on stream. He can hang out and chill with me. So... But he does like to snore and kick around and stuff like that. So just so you know.
Well, that's 100% allowed because
I figured it would be excused.
We're all for animal noises around here.
Yeah,
we're all for it.
Just get Valhalla noises if we don't get animal noises.
Sorry, I wasn't ready, y'all. I jumped in right as the intro was playing. I wasn't prepared. I was doing barn chores. I got stuck out in the barn longer than I meant to. But I'm here now. We're ready.
And thank you, Jim Cox, for 11 months. And what time is it? It's 1 a.m. So it's a little early for me, but Andrea lives on the other side of the world, so she needs a little special time.
I do. I live in the most inconvenient time zone for streaming, except maybe for Hawaii. I'm sure it's probably worse. But I have to plead guilty for being the reason for the late start today because I have to file something in court tomorrow, and that was on my to-do list today. So I needed to have the time to wrap that all up. But
and here I have to put in
accommodating.
I have to put in a disclaimer because I read on Twitter today that you are an unaccomplished failed lawyer.
Uh-huh. Yeah. Well, people who don't know how to put a lawyer's name into Westlaw will say things like that. Like, if there's anything that's more easy to verify than an appellate lawyer's record, I have a hard time thinking of what it is. But smooth brains will always reveal their capacities. So
smooth brains
I
will
love
always
how
smooth.
Betterow was the short bus attack squad's main target, and then he got kind of put to the sideline because of the Pro Hawk Vici, and then you
Sure.
became the main target for the short bus.
Well, I must be a big threat. So
I don't know what's going on, and the thing is, I don't understand how she determined that there was that conflict of interest with Betterow. But did you go through all 51 filings last week?
I don't have the count on the total filings last week. I did get the 30 motions in limine count, plus the motion on Crosby, plus the the habeas decision. So I may have not included a few earlier ones in my count. But yeah, it's just been a like spigot of new things as we're getting deep into the lead up to this trial here. But I did go through all of the motions in limine, and I think I'm pretty up to speed on everything. If there was something that I missed, I can let you know.
Well, I have my lovely Jemima, who is also a lawyer. She actually went to the same law school where Hank Special Prosector Brennan is. She claims she didn't take her class, but she lies a bit, so I think she might have taken this class.
She lies a bit.
But she was sending me the filings, and then it was like drop of 5, and I was covering another trial, then looking at them, trying to download them while you're streaming, and then 5. And people are saying, "Oh, can you read them?" Sure. 3 hours later.
Yeah. Oh yeah, it was a lot to go through, and I saw a lot of people were very much making the valiant effort to go through all of these one by one. I did not do that. I actually haven't talked much about the motions in limine, except just kind of in general terms. So this would be my first time really to get into the details of any of those. From my perspective, some of them are pretty rote, pretty routine, not really anything to get excited about. A lot of them are kind of repetitive of things that were litigated before the first trial. So really what's interesting about that is less the motion itself and more, is Judge Cannoni going to change? Is she going to change her mind on any of these previous decisions that she made? But then there are some new ones that are, I think, maybe a little bit juicy. So
I think the Crosby one is quite juicy because it goes straight against all her previous rulings, and there's no methodology, and that's very important. I have learned. Again, I'm not a lawyer. I just learned from the greatest legal minds, and methodology has to be mentioned. You don't have to file affidavits, but you have to mention methodology.
Yeah.
And there's no methodology, there's no affidavits, and his thesis is the opposite of what he claims in the brief. And back when they started talking about they found Chloe, I went back and looked at forensic orthontology. It's a really bad word to say in Danish. And that's bunk science. It's like tool marking and all that. It clearly states that you can't use it in this way. And every scientific study of it claims that even the people who claim they can do it says, well, there's so many asterisks with, well, the skin is elastic and you have to have the teeth on the day, you can't take molds, and it's everything you can't do.
Yeah.
So I think that's the most juicy one of the filings so far.
Yeah, I mean, what I really liked about it was I really liked how Mr. Alessi just called her straight out on the inconsistent standard. Look at what she required for Dr. Russell, a qualified, longtime practicing forensic, medical examiner, to be able to testify. And now is not even requiring a bare hearing, a basic evidence or record of the qualifications and like you said, the methodology, the reliability of what he's proposing to testify to. It just really, I think, has turned the tables for a lot of folks watching this case that have maybe been less inclined than some of us who are happy to share our opinions based on, what we've seen already about things like judicial bias and stuff like that. This really does seem to have gotten people's attention that, all might not be well. Maybe in the state of Denmark, but not so much in Canton, Massachusetts.
No, and it's that constant double standard that I think a lot of people are seeing, and that's another thing with the Short Bus Brigade, that they, all of you have just paid influencers. Yeah, we're grifters. That's what you do on this platform, because we don't mind that someone sends us a super chat. But I still haven't heard anyone getting any money from the defense. But we know that the state have some social media influencers going around speaking their case. Caffey Daffy.
Gross.
Yeah, and funny enough that Plevin could leak that the federal investigation was over before Brennan claims he knew about it. So it's this constant. I don't know what's wrong with this, but the more people who sees this case, the more people are saying this just doesn't make sense. And Bev comes. Have you seen a judge act like this? Where no matter how biased and how much they get called out, they're just sitting there saying, I don't care.
I have to tell you, from my perspective, Judge Bev is clearly pro-Commonwealth. To me, she is still kind of within the realm of what I expect from a prosecutor in a robe. Unfortunately, there are judges like that everywhere. That's just kind of the attitude that they have, where their default will be to adopt the arguments of the prosecution, to go ahead and rule in favor of the state or the Commonwealth. And there's a lot of reasons for that. A big piece of it is that judges rarely get in the position that they're in by advocating being soft on crime. We should be considerate and thoughtful about defendants and cases and consequences and things like that. People look for judges based on law and order types of interests. And so it's kind of natural then for them to want to service that when they're in office. And so there's often kind of this attitude of, well, I'll just, the state's given me an argument, I'll just go ahead and go with that. And if the Court of Appeals wants to step in and do something pro-defendant, let them go ahead and be the one who kind of takes the political consequences of doing that. Me, I'm still, on record as being a firm law and order, type of judge. So I can't say I've never seen anything like Judge Bev. I've frankly seen worse than Judge Bev. I just recently, from my perspective, saw, one of the worst judges I've ever, beyond worse than I've ever even imagined, over there in Delphi, Indiana. So she's not good. She's not good at hiding her bias. She doesn't seem to have particularly sophisticated legal reasoning. Her opinions are often just very brief. There's very minimal citation to law. She does like to assert, I know the case law, I'm familiar with the case law, but she, doesn't tend to actually demonstrate that when she's making a ruling. So it's annoying and it's difficult to deal with, and it's probably not how things should be. But I'm just telling you, as a practitioner, she's not really that extraordinary. That's just my read on it.
The part that flummoxes me is just like the chatter said a minute ago. She was a public defender her whole career. Mm-hmm. I don't know how you go from defending the rights of somebody who may or may not be guilty to just blatantly this bias. It's crazy to me.
Yeah, and I just have, we see all kinds, again, been doing this for a couple of years now, but when I do my layman duty, because we're with the judge, we go in and deliberate with the judge. We have a different system, and we can banter with them, and I've always seen them as we just had a new influx of young prosecutors, and they're really good at holding them to it, because we were doing some with online scam with buying a mobile phone on layaway and never paying for it, and the judge kept asking, but have you any proof that they made this purchase, and how did they defraud them? And I was like, these lawyers, they are living in their palaces. They don't understand how you make a quick loan, and you have to write, and then the company gets the money, and you never see them, so you don't. And I was writing a note saying, and the other layman was writing a note, and she just, when we had the first break, said, I know how you do it, but she has to tell us.
Mm-hmm.
Oh, yeah, that's correct. She has to tell us that someone actually stole from the company, because we're sitting there thinking, how privileged is this woman? But and I like that they put on that teaching hat when we are having new prosecutors, because prosecutors, they think they're always right, and they should do that because that's their job. But I've never seen anyone highly biased in our court system. But again, we're a very smaller setting, but I'm just with all of the publicity you have on this case, that she must know how people see her.
Well, she probably does, but it's just one of those things that it's kind of part of human nature. We tend to be blind to our own biases and our own shortcomings, our own cognitive flaws, so to speak. And I mean, there's been studies to the effect that if somebody has a false belief, presenting them with like facts that show that they're wrong, it doesn't serve the function of convincing them to change their mind. It actually has the opposite effect. It can entrench people even more firmly in that false belief, because they're just so psychologically attached to it. And so when you're talking about a belief like your own self-image in yourself as a good judge, impartial judge, very fair, I'm giving everybody a fair shake, it's, I think, going to be very, very hard to internalize criticisms and perspectives like that, even when they are based on things that, like Mr. Alessi's observation here, seems to be pretty objectively reasonable to me. Like I don't know how you look at these two, Daubert Lanigan motions and how they were treated so differently, and what was at stake in both of those, and not see the enormous discrepancy between how they're being handled. And of course, she doesn't even really try to explain it. She doesn't give extensive reasoning for why she thinks Dr. Crosby is qualified and why his method is good. It's almost like it's almost like it didn't matter.
I think it's intentional. I think that she intentionally doesn't answer these questions because she can't. She doesn't have a good reason for it right off the bat, right? Like, she's not gonna, even with like the objections in court. Like, she never asks for what the objection's for. She rules on it and then makes up something later if it's an issue. I think that's just her style for at least this case, probably for everything, I would assume.
And that was one motion from the defense. I was very glad to see they are moving to be allowed to state the basis for their objections on the record, because that is really important. I've said before that my view, one of the reasons why Judge Bev is doing this, why she is so vague and kind of non-committal in the basis for her decisions, is because it helps insulate it for later appeal. If they can't nail her down on what her reasoning actually is, then it's hard to point at that reasoning and say, here's where she analyzed a case and she misunderstood the holding of the case, and so therefore, she made a legal error in her determination. You're just kind of left to guess about how and why she was exercising her discretion, and that makes it a moving target that you have to kind of, shotgun approach to challenge that in an appellate standpoint. But the defense made a really good point as well, that especially with respect to the stating the objections, that they have to show, one of the things they have to show on appeal if they're going to try to raise an issue is that they raised it below, that they presented it to her and gave her an opportunity to rule on it. And she's really depriving them of that by not allowing them to say, this is the basis of my objection and the argument, that I'm making on it. So it is a very important point. I've always considered it pretty inappropriate anyway, because it shifts her a little bit too much into the hat of an advocate. Instead of asking the parties for her positions, she's going to assume what that party's position is and then rule on it based on what she thinks it should be. That's really not her role as a judge. It's an uncomfortable muddying of the distinction between being the referee and being one of the players.
I've been watching some of the highlights of the Darrell Brooks case, and one thing I hated about Judge Darrell was she spent 45 minutes making a record of every objection. But now you kind of want it. Because I also watched the Vicene case because everyone was saying, well, she's doing it because it's Brooks and she's going to prepare everything for
just your
appeals.
style.
Yeah.
And then I saw the Vicene case. Objection hearsay. I made a ruling according to Rule 4405. It is hearsay, which means that it can't be into.
Well, you know what?
That
actually,
takes 6 weeks longer by all of her. But you want the record because. What are you going to appeal on? And that's kind of the thing now with the habeas case, because did they object to the Tui Rodriguez here? So when she, what do you call it? When she threw it out in the end, did they object to it? So they can. That's what they say. Well, there's no rule to do it, but you. Wouldn't a good judge have said, okay, parties, I'm going to call them in. The Tui Rodriguez clearly states I must send them home now. Because that's the clear text. You must end it only one time and then you're out the door. But then you can file your objection now. I think most judges would have done it that way. But she also seemed like, I'm just going to get it out of here. And because people were, well, she should have asked them. No, the Tui Rodriguez clearly states she must only give them one more try, and then it's out the door. So she was kind of forced by that rule.
I think in some ways it was a little bit of a reflection of the same thing that we just talked about with her handling the objections, the way that she blurs the lines a little bit between being the referee and being one of the players and kind of anticipating what their position is on the issue. My read of this situation is that Judge Bev just kind of assumed everybody was going to ask for a mistrial. Everybody wanted a mistrial. Everybody was going to agree to a mistrial. Nobody was going to have any sort of alternative suggestion than declaring a mistrial. So she just went ahead and went forward with that. Rather than, if she had simply put the parties on the record, what's your position on this? You wouldn't have had this whole issue that has now escalated up into, a habeas appeal in the First Circuit Court of Appeals, because it would just be crystal clear whether that was something that the defense wanted or not. And as far as the options that she had, one of the strongest points that I thought came out at the oral argument and in some of the briefing on the habeas petition was the argument that under the statute, under the Massachusetts rules with the Tui Rodriguez instruction, once that's given, they can't be compelled to go back and continue deliberations, but they can if they consent to do it. And so one of the principles behind declaring a mistrial, it's got to be a manifest necessity, right? And there's this good case law out of the federal circuits that suggests that you haven't met that if you haven't evaluated alternatives to being able to declare a mistrial. And so an alternative here would have been simply ask the jury, do you want to deliberate anymore? That was also something that was never done. She just took it, on her own assumption that the jury wasn't going to agree to that. So, ultimately we know that the petition didn't go in Karen's favor. But the bottom line is that we would not have any of this. We would not have any of this going on at all if she had simply, as you pointed out, just get them on record and ask them explicitly for what they want, make them state it. And that it just cleans things up so much from the appeal standpoint, because nobody's having to assume anything about what they're arguing or what their basis is. You just make them put it on the record, and then that's what you go on.
Let me pay some bills here. Oh my God, Andrea, I learned of you back when you were on rackets law about the Idaho 4 case. Your coverage of that and the read has been awesome. Yeah,
Thank you so much.
You sadly went out traveling just as the Idaho 4 right after that, and I really wanted you on to talk about it because that was one of those cases I didn't really follow, and now I'm kind of seeing it. I don't know if you know UDO law from California, but I have had her on to talk about it. That's another case that's just...
That one's wild.
Yeah, we'll talk about that sometime for sure. I was gone at kind of an inconvenient time because a lot was going on. A lot is still continuing to go on in that case as well. You may have seen the 911 call got released this week. That's certainly gotten a lot of attention. It's a case where, because there is a strict gag order in place, there have just been the tiniest drips and drabs of information about the actual basis for the charges, the actual theory of what happened that led to the deaths of these 4 students, and what exactly the state has to prove that Mr. Koberger is the one that committed these crimes. So there's just a lot of reason that has emerged from the pretrial hearings that suggests this may not be, the rock solid case I think most people would want, given the nature of these killings. And so it's going to be in a very similar posture to Karen Reed pretty soon here, because it's gearing up for trial. It's scheduled to start jury selection on July 30th. Being a death penalty case, they kind of accelerate things like motions in limine and those types of pretrial hearings. So we're going to be in the flurry of all that real soon. It's already starting. And of course, now the overlap with Karen Reed's trial makes it very difficult to kind of keep track of both.
I can only imagine. Goodness.
And there's so many cases going right now where you also had the Delphi case where there was also a little bit of weird rulings going on. And now that's another case I had Mo on to talk about that for me, because I normally try to steer away from what everyone else is covering, because everyone else is covering it. And then you get to watch it and you get to listen to you or Mo, and you're sitting there thinking, this is just as bad as the one I'm covering. That's sad. But Maria says, Reddit is not nice on people how think.
Who think? Who think? It was a typo.
No.
Yeah.
Who think?
Stay away from
Reddit.
Yeah, Reddit's gonna Reddit, y'all.
Reddit's gonna Reddit.
And justice for John. Thank you, Doink the Clown.
Absolutely.
Grant Smith Ellis on that. If other lawyers, prosecutors, and others can see it so wrong, why is Henke still going ahead? Is it they don't care, or is there another reason, considering all the lies and video tampering?
There's about 250,000 reasons why.
Yeah, $1 million question, right? I mean, if nothing else, he's getting paid to go forward with it. So why wouldn't he? But yeah, you have to wonder, what is the motivation on the part of the Norfolk County District Attorney's Office to pay out this kind of money to retry her on such a marginal case, that they couldn't win the first time anyway. There's so much sketch around it. To me, it seems almost like a sunk cost kind of situation, where they have already gone so far down the road, just because the allegations of misconduct are pretty significant. They're pretty serious, and they're not unfounded. As much as folks, out there in some of the smooth brain brigade like to run around and, suggest it's all a conspiracy created by the defense and so forth. No, I mean, there's objective reasons to look at this and notice that, for example, Trooper Proctor, concealed the date of the time that he, or actually flat out misrepresented the time that he took custody of Karen Reed's SUV over there in Dighton for like years until he got called out, and they were able to, demonstrate with other evidence that in fact, he had it an hour before he was claiming to. All of these just what I think are perfectly legitimate questions about the way that this investigation was conducted, the fact that the car was allowed to be taken to the conflicted Canton Police Department in the first place, the just extreme disregard for ordinary procedures and protocols with evidence collection and documentation and securing and chain of custody and so forth, the overwhelming shenanigans with the video evidence, the coincidence that at all the times when the Canton Sallyport PD Sallyport video would show the condition of Karen Reed's taillight when it was first in their possession, that has just all mysteriously vanished. The library footage under the city's control when she would have gone by mysteriously vanished. It's a remarkable number of coincidences. And the thing about coincidences, they're circumstantial evidence. It's a question of the weight of the inference that you can draw from that. And so it's not at all unreasonable for people to draw the inference that you screw up an investigation this badly, there's a reason for it. And it's because you don't want that investigation to be solved. And then lo and behold, what do you have? You have texts from Trooper Proctor to his good buddies the day that this is happening saying he's a Boston cop. He's never going to have any consequences. So it's not at all a vast defense conspiracy. It is very, very well grounded in the evidence in this case and the problems that law enforcement created for themselves.
But do you think that they missed an opportunity? Because I think the defense actually gave them a really good chance of saving this case without egg on their face. Blame Proctor, get out of here. Mm-hmm. Because they could, when they were asking to dismiss the trial and they just threw everything at Proctor, and Hank did the same, said, yeah, he kept the videos. None of us. How could we know that the lead prosecutor, it's not like it's a Brady violation just because the lead prosecutor doesn't turn over evidence. Come on now. It's even though the Brady rule clearly states any agent working on the case bears the Brady obligation.
Proctor might be a bigger liability though. If they go and dump it all on Proctor, Proctor could turn around and be like, "Oh yeah, this is where it came from. The reason that I have these text message threads with my superior officers about this topic is because this is what's done all the time." So that actually makes a little more sense to me now that I'm thinking about it.
Yeah, no, I think Val's making a very good point here, which is it's the prisoner's dilemma problem, right? They have to keep everybody on side, and the only way they can keep everybody on side is by continuing to have everybody's backs, and that's how a corrupt system is going to work anyway. It's not going to be based on explicit promises. You go ahead and plant this tail light and I'll, make sure you get this benefit in the future. That's one of the reasons why it would be very difficult from my perspective for a federal prosecutor to establish some kind of federal crime that they could charge as a result of, what we've seen and what we could maybe infer to be misconduct by the police in this case, because you typically have to show a quid pro quo to establish corruption. And so, when it's just this nebulous, hey, you got my back, I got your back, and everybody will kind of keep looking out for each other, it's just much, much harder to establish that type of explicit arrangement. So the fact that he's still getting this public support. I mean, even Mr. Brennan now trying to keep the fact that he's under this IA investigation. The fact that Buchanan and Tully and I think Fanning also get disciplined. They had the sustained findings as a result of the IA proceedings relating to the texts involving Karen Reed. Wants to not have any of that come in, which seems to be, it's it's a baseless motion from my perspective. Like, of course, this stuff is admissible. It's misconduct relating directly to their investigation of this case. It goes directly to their credibility as witnesses. But it's more symbolic. It shows he's still got their back. He's fighting for them. So don't think about, don't think about turning, flipping and letting things go. They're not going to give him the incentive to do that.
In the Rintala case that they mention now as with the witnesses, I covered that, and actually they weren't allowed to talk about the lead investigator in that case because he had also been disciplined, and a ton of people had been disciplined in that case as well. But they were not allowed to mention him, and not to imply that he could have been brought. And it was Rosemary Scapiccio, who's one wonderful lawyer up there, who and she implied it a whole heck of a lot, but she didn't care. It's the fourth time they tried this woman, and there was, guess what, tons of shenanigans. They had a paint drying expert to testify how long the body had been done, and they had an EMT testifying about rigor because she was in this position. So he grabbed her wrist and did this and established that rigor was kind of 6 to 8 hours in.
Okay.
Yeah. Andrea, do you think the Commonwealth will be able to keep Aiden out of the courtroom?
Well, he's on the witness list.
Yeah, that's the $1 million question, isn't it? So he's on the witness list, and that normally means he's going to be sequestered, right? He's not going to be allowed to watch the trial. He's not going to be allowed to talk to anybody about what's going on. And
unless you're Jen McCabe, then you can sit in court.
Yeah, well, the other one who got the exception last time was Gretchen Voss, right? Gretchen Voss was a journalist, and she was on the witness list, but she got an exception to that sequestration order that allowed her to continue to attend the trial. And so I expect that Dr. Turtleboy is going to do the same thing. He's gonna move to be exempt from the sequestration order. Now, is Judge Cannone going to give it to him? That's really what the $1 million question is. And, we already saw that she was kind of happy to kick him out for, what I considered to be pretty questionable reasons in the first trial. He couldn't be there when certain witnesses were testifying because of, they had the no contact orders against him or whatever because of these, charges that he's had trumped up against him for witness intimidation, charges that, are subject to motion to dismiss because of the First Amendment implications involved. But it's just kind of clear from that history that Judge Cannone already doesn't think much of Dr. Turtleboy. It seems like she probably isn't going to be all that receptive to why she should give him an exemption. And I think part of the problem that's lurking there for him is that Brennan is now trying to get the discovery from Dr. Turtleboy's witness intimidation case and be able to use that in the prosecution of Karen Read. And he's arguing all this stuff about how it's all relevant to witness intimidation. It's consciousness of guilt because, he and Karen Read, they allege, conspired to try to get the witnesses to change their testimony, something like that.
They had a grand jury saying there was no basis.
I know. And the thing is that even there are some of these texts that are already out in the public sphere. And it's kind of no secret that Turtleboy and Karen Read were in communication and they shared information and evidence. And he, would clear it with her before he would publish it. But the thing is that none of that shows any sort of collaboration whatsoever on anything besides journalism. And so,
and you are actually allowed to try and sway the public opinion because Meatball Morrissey did it.
Yeah, of course. Well, I mean, that's the whole thing. The lawyers are subject to the rules of professional responsibility when it comes to their extrajudicial statements. Karen Read is not a lawyer. She's not subject to those rules. So the judge cannot like it, but it is her right to go out and defend herself. And particularly when it comes to things like influencing discretionary political types of decisions. Like, I don't know, should we charge this woman? What should we charge her with? Should we retry her after a jury has already, failed to find her guilty? Those are the types of things that, yeah, she has the right to use her voice to try to influence those decisions, being made. So it's First Amendment activity, once again, that is kind of trying to be distorted into something that's far more nefarious. Nevertheless, we already know that Judge Cannoni takes a dim view of Karen Read defending herself in public. She's kind of chastised Mr. Jackson based on what he did during the Gretchen Voss interview, the stuff that she got to see in the confidential notes and stuff like that. She really didn't like that. So I suspect it's going to be a situation once again where it's not going to be the same rules for the Commonwealth as it's going to be for Karen Read, when the prosecutor and the prosecutor's witnesses, like the family of Trooper Proctor, go out and make big public statements about the merits of the case. They don't even get a wrist slap. They get nothing. I guess Morrissey technically got himself disqualified, but not his office, and it's still allowed to be prosecuted and so forth. But I just don't think she's likely to give the same kind of grace to Dr. Turtleboy and Karen Read.
No, and that's my problem, because you might not. That's what I always, even when we see those dirtbags that we know are guilty, you have the rights to be defended, and you have, because you go on some channels, people always, oh, shut up, defense, he did it. It doesn't matter. You have the Fifth Amendment right to a defense and to get your day in court. Mm-hmm. And you should be playing on the same playing field, and one side shouldn't be uphill and the other side shouldn't be downhill. It should be a level playing field. And sadly, Kent, Massachusetts, unless you're one of those who are allowed to drunk drive, you won't get a level playing field. Drunk driving is allowed as cops in.
Well,
Canton.
if you have a badge, so. Yeah, you got to have a badge, and then you're good.
Live, according to Martin, can the defense call for judicial misconduct?
Well, so they can, but the question is that likely to get them anywhere? And so they already tried it. They already tried arguing that Judge Cannoni is biased and that she should be disqualified. In Massachusetts, she's allowed to rule on that motion herself. She doesn't have to kick it over to an independent judge to, decide for him, which it seems kind of reasonable that you should not be deciding whether your own behavior has given an appearance of partiality in a case.
I'm unbiased.
Nevertheless, I'm totally fine, and I'm pretty sure. I remember, she examined her conscience to determine that she would be fine.
I understand the charges against me, and I have investigated them thoroughly, and I have found that I have done nothing wrong.
Yes,
I'm
100%.
Pretty sure you should be watching on this stream. This is the best stream right now on YouTube. I checked YouTube. It is.
Yeah. So, they're already at a disadvantage because she gets to make that decision. So then what? Okay, well, you can appeal it. Can you appeal it on an interlocutory basis? Maybe, but unless you got a really, really strong showing, something that's extremely overt, that is clearly going to, satisfy a showing of actual bias, a showing of, specific judicial misconduct. And these things are pretty specifically defined because judges get a lot of leeway and a lot of discretion to decide how to do their jobs. Unless you can show something really pretty unarguable, they're unlikely to get interlocutory review. So they can raise it for purposes of preserving the issue and raising it on appeal if she's convicted. The problem is, though, you kind of poison the well when you do that. She already hates them. She already hates them. How much harder on themselves do they want to make it by trying to raise something like that? The reality is just that it's an extremely difficult hurdle to show that a judge is biased. You typically don't get to just point out here's their pattern of rulings or things like that, because number one, the court will bend over backwards to point out, well, there have been times when she's ruled for the defense. She hasn't been completely on the state side, but there's also just a general disfavor towards making those kinds of decisions based on their rulings anyway. What they want is something like her explicitly, insulting them on the record, or something that's just so overt,
so blatant.
Yeah, that it really is undeniable. And those types of things are pretty rare, because judges are pretty good for the most part at keeping their true feelings close to the vest.
Yeah, and again, you don't want to kick the hornet's nest when you have to sit in the same room afterwards. And Bev will never be taken off. I think there's a lot of people out there who still hope for abracadabra, but abracadabra just doesn't happen. Feds doesn't come storming in. Judges don't get removed. And I saw people, well, they should move venue. Why? Bev is going to move with them. The only thing they'll get is, they know, at least right now, with the 600 people they went through with jurors last time, they got a hung jury. That means that there's a lot of doubt in that community. I would say it should be the state that should try and change venue to something where it's not as public as it has been. Andrea, do you have an opinion on the Commonwealth's response to motion to dismiss, for example, regarding the non-communication from the investigators, asked Diane G.?
Oh boy. So you're asking about one of the ones that I have not looked at in the last maybe 3 days. So isn't at the forefront of my mind. I mean, the motion to dismiss is it's always going to be a bit of an uphill battle, because even when you establish misconduct, you have to show that the sanction of dismissal is, the most appropriate one. There's a lot of different ways to sanction prosecutors, law enforcement, etc. So, I mean, I think that boy, what are some of my initial reactions to the motion to dismiss and the response? I mean, a lot of my reading of the response, I find it it's honestly, it's really annoying to read a lot of Mr. Brennan's stuff. And the reason why is because he just kind of asserts things and doesn't substantiate them, doesn't back them up. We don't know. Where's our affidavits? We have this joint affidavit from the 3 prosecutors about facts that are not things within their personal knowledge. They would be things that they were kind of told. As far as, how the accuracy of the video and so forth, they don't know this. They're just taking it on faith from what the investigators have represented to them. All they can really personally attest to is their own efforts to reasonably inquire into, the potentially exculpatory evidence that's available, and, make sure that they get it and make sure that they timely turn it over. It doesn't matter if, like you pointed out, it doesn't matter if law enforcement had it and just didn't tell them. That's not an excuse to Brady. That's very, very crystal clear. So I found that a little bit odd that it was very much a pass the buck kind of response. It's not us, it's them, but it doesn't matter. It seemed
the same team. It's all the Commonwealth. It doesn't matter whose fault it is. It's your fault.
It seemed very personally face-saving, and particularly for Mr. Lally, because of course Mr. Lally is the one who signed the certificate of compliance saying, I've made the reasonable inquiry, I've produced everything that needs to be produced, and then continues to produce things over the course of the trial that then ensues. Something I saw that I found very interesting. I was looking over the order that Judge Cannoni had signed. It was the order where she both denied the sanctions against Mr. Jackson and then issued that gag order. So I put out a quick thing on Twitter about that, just clarifying kind of what the scope of the gag order was, because I saw a lot of people getting very nervous about it. And honestly, my read of it is that it's kind of a nothing burger. It's really not doing anything other than just reaffirming what the rules already are. And it's making them potentially punishable as contempt. Normally, things like the extrajudicial statements that would violate the rules of professional conduct, that's not a court order. It's not something that the court can hold you in contempt for if you violate. She can just refer it to the bar overseers or the the commission on attorney conduct, or whoever their organization is that does attorney discipline. So that's really all it's doing, is it putting it in a context where if she thinks the statements violate the rules, she can impose sanctions, and it does apply to both attorneys, although we can imagine how that would be actually carried out. But anyway, what I was getting at is that in the part of that order where she was addressing whether or not she was going to sanction the defense counsel, she cited this case, and I'm going to see if I can pull it up because I don't remember now off the top of my head what it was called. But it was a case that involved discovery violations, and it was discovery. It was a situation where the Commonwealth had signed a certificate of compliance. And then, later on, it turns out that there was more that they hadn't produced. So the defense had gone and asked for sanctions based on that. And that in that particular decision, the court had found that, yes, this was in fact a violation. This was sanctionable conduct. The question concerned, like, what exactly is she allowed to do? What is the judge allowed to do as a remedy in that particular context? So I found that interesting, even though it's not directly dealing with the motion to dismiss. It's clearly relevant to the motion to dismiss, given that whatever Judge Cannoni's other virtues are, she does not seem to be an exhaustive legal researcher. This is likely to be a case, that you would think, you would expect her to rely on as well when it comes to evaluating whether the Commonwealth engaged in sanctionable conduct, and if so, what the appropriate sanction is. So that's just going to be an interesting thing to kind of wait and see when we get her ruling. Is she going to remember that case? Is she going to apply it correctly, or is she going to, try to look for some other workaround? I'll be waiting to see.
I love the shift that there was in the last time in court, because she clearly doesn't remember the first case. She doesn't remember her own rulings, and we talked about it. Why don't she get a spreadsheet from her legal assistant saying, they are applying for this ruling, you have ruled on it before, this has been ruled on by the previous judge. But no, I was here, I remember. No, you clearly don't, because you're going straight against what you said. But the way I can just get it from Miss Little, and she was like, yeah, I have it here. And first of all, the disdain, treating her like a paralegal when she's a partner in a law firm, that's one thing. But just that she had it every time she was asking for anything. I really like the dynamic of Alessi and Little, because Janetti and Jackson are really good talkers. But it seems the other two are really good facts. And you need those people to take technical evidence and provide it for the jury, because especially in this, I don't understand. I had Video Jesus on last week.
Oh, awesome!
And my brain was just that Simpsons episode with the monkey with the just clapping its hands, and I'm just sitting here.
Yeah, and I agree completely. That's where Mr. Alessi and Ms. Little, they are detail people. They're fact people, and they're good organizers. That's what's been so impressive to me about Mr. Alessi and his advocacy. He is so organized and methodical and systematic. He understands the structure of an argument and how to lay the foundation to be able to bring you along until you have to kind of necessarily reach his conclusion if you follow all of his premises. So that's exactly the kind of skill that, from my perspective, is so important in a case like this, with so much technical evidence to keep track of, and then just so many details. That's where the defense cases is really fleshed out. The details about when exactly all these butt dials were occurring and to whom, where exactly all of these pieces of taillight were found and when and by whom, and where did they match into the taillight. And, all of those types of pieces are really where I think the defense case is best able to be made, but being able to organize and present that in a clear way to the jury so that they can see, oh yes, all of these problems, they just maybe sounded like isolated things when we were at trial, but now I understand why they're significant. That's where I think Mr. Alessi has the potential to really, really benefit this defense team by helping them just better organize so much of what they already have, so that it just walks you down that path to the conclusion that, look, there's no way they just found all of these pieces, of snow or pieces of taillight lying on top of the snow. Given that here's the video that showed the amount of snow on the ground in front of the library right around the time when, John was supposedly hit and would have been left. Here's the photograph of where John was found the next morning, where clearly he is on top of snow. There's no, bare area where he would have been found. Just all of those details are where showing the problems with the Commonwealth's case is going to have the most bang. So I'm really, really excited to see what he brings to the team at trial.
And the way he's just, you have that duality that clearly shows, I have this book for you so you can read along, Your Honor. And it's page 50, line 7. Mm-hmm. And then, do you have a quote for that, Miss Brennan? I can get it to you. Mm-hmm. And it's constantly and one person is saying that Betterow said, he was on Young Jerks earlier, said the statement in court by attorney were not sworn, so Brennan can lie all he wants without concern unless he puts it in writing. Well, again, you can, but you can also lie so much to a judge that she will turn on you. We were talking about it earlier. Do you want to agitate the judge? And if you keep lying to Bev, even her patience will run out at some point.
You would think, you do have to question, like we just had this whole series of hearings about the duty of candor to the court. Like, you can't, like, yes, you have to swear under penalty of perjury like any other witness if you're signing an affidavit that's going to go into court. So you can't be punished for perjury. You can't be prosecuted if you, a lawyer, go in court and say things not under oath that turn out to be untrue. But you can have a major ethical problem in terms of your candor to the tribunal. But we've just seen that the rules really don't evenly apply. He went in and made that whole statement, that whole insistence that Mr. Yannetti had made the extrajudicial, statements on court TV, and it was actually a court hearing, and he doubled down, that it was on court TV and court TV wasn't in the courtroom. And he, later filed this correction of the record where he acknowledged that he was wrong about that. But it was, before that Judge Cannoni had signed her decision where she just basically acknowledged that happened and that, it wasn't extrajudicial, but no chastising of Mr. Brennan, no be careful next time, nothing at all, after laying into the defense counsel and having their, pro hac vice status, Mr. Jackson's anyway, on the chopping block. You gotta question the appearance that the standards here are being applied equally to both sides.
I don't think they're concerned about it in the slightest. I think it's been this way in Massachusetts forever, and it'll continue to be this way forever. I think it's just par for the course up there.
Yeah, regrettable. He didn't say actually that he regretted it or was sorry for it, just it was regrettable. Always look for the passive voice. That's definitely something that you learn as a defense attorney as you're reading through a police report. The passive voice, that should set off red alarm bells that you need to be asking questions about how do I transform this into active voice. Why?
Nice.
To whom was it regrettable and why? Who is feeling the regret, Mr. Brennan?
Didn't they describe Proctor's text as regrettable as well?
Oh, probably. Yeah, I'm sure.
I actually think he had some regrettable statements in his text, but blah blah. He's still the greatest police officer.
Yeah,
ever.
yeah.
Sure.
That rings a bell.
Different. That's different language than the first trial when it was disgusting and grotesque messages or whatever. Lally ripped into Proctor as he should for those text messages, and now Brennan's trying to kind of sweep that under the rug a little bit easier.
And Red Pointless Pen says, great panel. Ask Andrea if she thinks defense should employ ceaseless sidebars for every single prosecution objection can only disallow speaking objections in this trial.
It's definitely a strategy, to go in and ask to argue, every single issue. The risk is that you piss off the jury, by doing that, because you're wasting their time. They're bored. They don't like it. They want things to be moving forward. They don't want to have to follow an examination or a cross-examination that's super disjointed between the question and the answer because you got all this argument going on in the meantime. If they had a high likelihood that she would grant them all, then you go ahead and make the effort because the jury then sees you're doing it for a reason. But this is Judge Cannoni, so that's probably not going to happen. Because of that, I think you have to strategically reserve your main arguments for the ones that you really do need to make that record for, potential appeal purposes, that you have this wrong and here's why you have this wrong, and do what you can to try to get her on record with why she's making her ruling and why she's not agreeing with your argument.
And what about Mr. Brennan going through Morrissey's private emails because he couldn't trust the taint team? Well, they only work for the same company, so why should he trust them? He got the info in the first place. He knows they're not to be trusted.
I don't understand this at all. He doesn't trust the taint team. The taint team is there because of him. That's the whole reason you need a taint team, is because he's got the potential conflict of interest. So I don't get how that's allowed. I really don't. I've been on record many times saying I'm really negative on prosecutorial taint teams anyway. Their incentives are not aligned with being objectively fair about what they're looking at and what they're evaluating. But nevertheless, at least the idea of getting it removed from the people that have a direct stake in what it's going to reveal is kind of important. And the bottom line is that Mr. Brennan is financially indebted to Mr. Morrissey. So I don't see how you get around the conflict of interest there. And doesn't he make himself a witness? Yeah, that's what I'd like to know. Million dollar question. How is he not a witness to what is in those emails, whether there were any, first of all, and if he decided, some of them are okay, some of them are not okay, what's his reasoning for all that? It just brings him right into the middle of the controversy, and that's not where he should be, given that he is the prosecutor on the case.
Yeah, and the big problem is it's the same with perjury. As long as you lie for the state, you'll never catch a perjury charge. And this, who's to say, he even said it in the last hearing that it's not for the defense to determine what's evidence. Well, it actually is. You should just turn over everything. Yeah. Everything you find, even if it's just a handwritten note that says Karen it could be Karen Reed, you get that. But no, it's not for the defense to determine what's exculpatory evidence.
Yeah.
You turn over everything. It's especially not your job to figure out what's exculpatory.
Don't you just have to wonder, why be so resistant? Why on earth, if you're the good guy, do you not just have an open file policy? There's plenty of prosecutors out there that literally have an open file policy on discovery. You can go into the prosecutor's office anytime and you can look through their entire file and you can see what they have and who they've talked to and so forth. There's just really no reason to try to be concealing things if you're running a clean investigation. And all it really does is increase the risk that you're going to exercise your judgment incorrectly and you're going to withhold something that you should have turned over. So I don't, there's a cost benefit analysis in there somewhere that I want to give the benefit of the doubt to the prosecutors that it's not for dishonest reasons, but I just have a hard time doing that calculation and figuring out what else would justify taking on that kind of risk.
I've been saying it throughout the first trial, even if
you're muted.
My bad. If they're not framing Karen
really
Reed,
good argument you made, by the way.
If they're not framing Karen Reed, right? If they're not involved in this cover-up, they're trying awfully hard to make it look like they're framing Karen Reed and involved in a cover-up.
Yeah.
No, I agree normally completely. You see the document dumps to hide every piece of evidence. In this case, no, we don't have any. Might have talked to a witness, we don't know. And then, the defense found out that instead of going over to the crime scene and investigating Jen McCabe, we told her to go to another residence so we can. Why should we go to a crime scene? It doesn't make. Come on now. Oh, weird.
Yeah.
Turn over all the evidence you have so we can see what is. Can they bring up the first trial? Yes, prior hearings. If not, how do they impeach them with testimony from the first trial? They can, but they can't say the result of the first trial. And they can't say...
I mean, it's going to be, I think it's going to be interesting to see how Judge Cannoni navigates this, right? Because if she even allows them to say first trial, it kind of implies the outcome, right? If she had been convicted, we wouldn't be here having a second trial. So I suspect she's going to make them sanitize it with something like a prior proceeding or something along those lines. But yes, they're absolutely going to be able to impeach the witnesses with their prior sworn testimony in the first trial. Here's where I think things get a little bit sticky to navigate, and I'm definitely going to be interested to see in how Judge Cannoni navigates it. That's with the ARCA witnesses. And so we know, the defense has filed this motion in limine to try to preclude the Commonwealth from being able to argue that at least certain of the costs have to do with bias, right? Don't let them talk about the voir dire costs because that's not something that, the defense, incurred. It's just something that they paid because it was done for the defense benefit. But the whole notion of the Commonwealth bringing in the ARCA payment, this to me is very, very, very complicated, and it may very well be like in a reasonable court. I would expect this to be a be careful what you wish for situation, because you don't get to use the fact that the defense paid some of those ARCA costs and not allow the defense to put that in context about what they paid for and why. The Commonwealth cannot imply that their opinions, their work, the scope of the decisions that they made, and so forth, were influenced by this defense payment when it doesn't work like that chronologically. The defense is, from my perspective, going to have to be allowed to explain, no, we didn't pay for any of that. They had already been hired by somebody else who defined the scope of their work, defined what they needed to do, what they were to look at, and they reached their independence and were paid independently by that other source, not us. Then, of course, that opens the door to their request once again to be able to explain. It was the FBI, it was the Department of Justice that hired ARCA. You need to be able to understand that for it to be a fair context, because I remember this came up in the first trial when we were watching the first trial, and they have to say, it was, in a different proceeding or whatever. That was how they sanitized the federal proceedings. And I remember thinking, well, if they're what other conclusions could they maybe reach? Well, with, ARCA, if they're hired by some other entity, my natural assumption would be the insurance company. I would assume that there's an insurance company involved. And lo and behold, turns out, at least one of the jurors, that's what they're thinking. And then apparently another one that argued that, they just, involved themselves because they wanted the fame and the notoriety and stuff. No, like that's not fair. That's not fair context. It's not true. They were hired by another law enforcement investigator. So it's just one of these situations where the judge does have a lot of discretion to weigh what's prejudicial, what's probative, how do they balance out against each other. But you really are supposed to weigh that in favor of the defendant because of the presumption of innocence, because of the right to present a defense, and so forth. And so it just does not seem like she got that benefit in the first trial with the way that she put the constraints on it. Now that there's this additional layer of the Commonwealth is probably going to try to muddy the waters here with the defense payment to them. To what extent are they going to be able to clarify, look, this is fucking what ARCA's role was, and this is our place in it, and here's the other people's place in it, and that's...
Well, especially since they announced now that investigation's over, right? Like, there's nothing that should preclude that information from coming in, right? I can't...
No, because then Brennan can just stand up and say, but no charges was brought, wasn't it?
Right,
was it?
right.
That's not
the
our
cure
job.
for that,
We just do the math.
Yeah.
And but again, it's one of those where you're thinking it's really bad for them if they get to do and I really hate that question because it doesn't matter if you get $500 or $800 an hour, because I'm pretty sure even the lowliest law clerk who works down in the one who just stamps whatever goes over her table, she gets paid to be there because it's their work. And ARCA, it's not like it's Dr. Smeagol from the Johnny Depp case who I watched the movie, he was drunk.
That was terrible.
Yeah.
How much do you charge an hour, my good sir?
Yeah, seriously.
How on earth can Brennan fix this? Also, Andrea, did you see the juror interview? Yeah, we could hear that. I'm late,
I am so behind on the juror interview. I am like 2/3 of the way through the juror interview on Turtle Boy's channel. I was like totally into that, and then we had like this chaos at my house where the water line broke, and I had to deal with like excavators out in my yard. All this things have gone. And then my dog, like things have just been a little bit chaotic. So I'm catching up on that. I see in the meantime, then also he's gone on TV. He's given another interview. I haven't watched that at all. So what I have seen so far, I like this particular juror. He seems to be very, he seems to be very intelligent. He understands how to communicate what was happening. He's very clear. He's very systematic. He's able to distinguish, I think, between his own personal view of what was happening and the way that others were processing what was happening and communicating that. That said, the way that he is communicating what some of the other thought processes were, it's alarming. And his comments about some of the misunderstandings that they had, the misapprehensions about the law in particular, are pretty disturbing. It's always like one of the big concerns that a lawyer has is I can argue the facts to them. That's my job. My job is to persuade them why they should believe my version of what happened. But I should not have to argue to them what the law is. That's like a whole different level of persuasion that it's just not appropriate. They should be able to rely on the instructions that they're given from the judge. And if that's not clear, it should be clarified, by the judge. But then it gets complicated by this whole structure where you have a foreman who's the only person who gets to communicate with the judge, the only person who's authorized to, write the notes and send them back. So then the foreman ends up being this kind of just intermediary who gets to vet the validity of jurors' concerns and things like that. And so that kind of seems to be borne out in some of what the juror had to say about them being unsure about whether they could return a partial verdict or not. And the foreperson, according to the interview, said specifically, no, we're not allowed to do that. So it's very, very troubling. Juror interviews in general, though, I love them. I know that the defense team loves them because they just see them as an opportunity to vet what worked and what didn't. And it's just kind of the norm that jurors almost never see the case the same way that the lawyers do. They almost never emphasize the same things that the lawyers do. And so learning kind of what mattered to the jurors and what didn't, that can be a really, really important part about adjusting your strategy for the next time around. So I have no doubt that the defense team has watched all of these interviews, has dissected them, has thought about the implications of them, and will likely rely on what they've heard to adjust going forward.
I would imagine so.
And I think actually one of the things that who was it? Was it in the Birdsmore? No, not Birdsmore. One of the trials where someone mentioned that all of this law tubing, YouTubing, whatever it is, they're beginning to watch it because exactly lawyers don't really understand people because you're really good at the law, but cases has nothing to do with the law. It has all to do with the law right now. But the minute the jury steps into the room, it's, oh, she made a face. She's probably guilty. He has tattoos. He's probably guilty. My car broke down on the way over. You're going to jail, buddy. And that's one of the things that, because I get a little bit, because I don't have a law degree, so I get annoyed when you're sitting there and people drone on and it's not important. Move. Well, it's really important because no, you have 12 people sitting right there and they're thinking, I could really have a smoke and a cup of coffee right now, and I'm listening to this idiot on hour 2. Shut up. And I think that's one of the things that the defense's case will only get better the second time around. The state can improve their case. Well, they can bring in a guy who can stand next to a car and say, I think his arm was outstretched or up in the air, or and then you're going to impeach Trooper Paul with his lack of knowledge of how the car was. So your case will only get weaker the second time around, but the defense can listen to all of the jury things and say, okay, we're going to try and get the technical data in a little bit better. The ARCA guys somehow try to imply that they are feds. They can learn from this, and I think we know it's a good team. They are learning.
Yeah, they will.
No, I think I was just going to say, I think that that's really important too in this particular situation in light of the juror interview, because one of the things that we heard was how the defense essentially, the jury didn't think that the defense proved their theory, right? And that's, of course, exactly the wrong way to be looking at it. The defense doesn't have a burden of proof, but that's always the risk you have when you pursue a third-party defense strategy, is that it implies that you do. It implies that you are asserting something that you then need to be able to back up. And so that's something I'm kind of wondering if we might see a little bit of a shift on going into the second trial. There's always difficulties getting jurors to embrace the concept of reasonable doubt, to really internalize that and understand that and think about that, and the burden of proof, how that relates to whose job it is to tell you what. So ideally, in a good trial, that priming process starts in jury selection. It proceeds through your opening. You are able to emphasize it over the course of the questioning and the types of questions that you ask and how you elicit information. And then you hammer it in your closing. So I do wonder if they may shift their strategy a little bit. And part of the hint of that was from the Karen Reed, the latest interview that she did, not the documentary that's coming out next week, of course, a whole other thing we have to look forward to. But the interview that she did with Alan Jackson, where when they asked who did it, they took the position, we don't know. And honestly, that really is a better position than to try to point the finger at, specific people that when they can't back it up. If you can't actually prove that somebody else did it, you're much better off saying, I don't know, But all these people over here look really sus. And so, given all of this really sus behavior, given that combined with the inability to prove that John O'Keefe was hit by a motor vehicle, that is what constitutes reasonable doubt in the case. And that's why you acquit Karen Reed, not because she proved to you who the real killer was. That's not her burden. But because the Commonwealth didn't. The Commonwealth didn't adequately rule out these other people, and they did not adequately establish that it was her.
Yeah, and I think that was actually a big problem in the first, because it also gave Lally the opportunity to say, what if any, a million times, and bring in all of these non-important witnesses to kind of fend off the third-party culprit defense. And they don't have to say, well, we think it was Colin in the rec room with the chandelier. They don't need to say it. They just have to say nothing aligns with a car hit. Nothing.
They can lay out all the possibilities. They can say, look, if Karen Reed didn't hit him, who did? Well, we don't know. It's not our job to prove to you, but here's what we can show you. We can show you Brian Higgins had a motive. We can show you Colin had a history. We can show you that Brian Albert had a history. We can show that all of them were behaving really, really sus, around this time frame. And so all of that should lead you to question the Commonwealth's theory here, and particularly, why did they conduct their investigation in such a way that it deliberately diverted attention from these folks who seem to have such clear and obvious, connections and reasons to be under suspicion?
Have you been watching the guy doing tail light testing? Yes, I have, and it's very, very interesting to watch, especially the latest one with the breaking point, because we all know a polycarbonate plastic shell doesn't just go, even if it's cold, which it wouldn't be because the car had been driven and blah, blah, blah. You have all of the different pieces found at all the different times. And there's it's really interesting. And I really like that he did the diffuser part. There's that no white light.
So compelling to me, because there's photographs of the pieces of the diffuser in evidence. Like, they say they found those on the ice, and if they found those in the snow, there is no way that the tail light could light up. I mean, that was such an effective demonstration. I would love to see something like that in court. I hope very much they have something like that lined up.
I was yelling at them get that drawing of the person next to the car, so you can say, okay, he had to be standing like this to hit the tail light, or like this. And I'm a demonstrative guy. I really like visuals. I do it when they're describing crime scenes in my court. If there's no photos, it's some violence and people out drinking. I like to sit and draw it to say that doesn't match up. Or, that makes sense now. I really need it, but Bev had ruled against a lot of it. So, but judge can only be tired one day and forgetting the excessive numbers of taillight pieces. I wonder if she was a functional substitute. No, just because I always say there's no law without the claw, it doesn't mean that she has a drinking problem.
Trial is always exhausting. It really is for everybody. I can't hold it against somebody for not remembering details. I can hold it against them for not taking the time to do it right and to refresh themselves on what actually happened before they make critical decisions.
Oh, and by the way, hey, Kelly Reed, she was in chat earlier. Yeah, I did, which I thought they should have used it in court, because I believe this is what happened that day. This is my theory. They didn't call me back when I said, "Do you want it for evidence?" So I don't know why. That's They have high standards. I declare Andrea to be objectively smart, incisive, and beautiful. Always love seeing her on stream. Oh,
thank you for that.
Yeah, you have a lot of fans out there. Thank you so much for joining us.
Very blessed.
I would love to get Andrea's thoughts on Bev's motion ruling that added names and her ruling where she added names and details that was redacted. Yeah, that was one of her brain farts.
Yeah, wasn't that ironic? Wasn't that ironic? She's chastising the defense for, you need to be more careful about not referencing the impounded stuff while she is referencing the impounded stuff. Classic.
What are some questions you would ask at jury selection?
I haven't sat and thought about specific questions that I would ask, but I will tell you just in general what I'm usually trying to get at in jury selection. I'm trying to get at a couple things. One, I'm trying to figure out, how do people communicate? Are these going to be people that I can talk to and that are going to be receptive to listening to me? People that are automatically in favor of the prosecution or law enforcement, they're very likely to just, they're not going to hear me. They're not going to want to listen to what I have to say. And so they're, just not going to, they're going to shut that off. I'm always interested in finding out if people are generally open. Are you open to changing your mind? That I think is really, really important, and maybe even the most important characteristic for a juror to have, because just even structurally speaking, the jury is going to hear the entire state's case before they hear mine. Even if I even have one, they're going to hear the direct examination before they hear the cross. And so if people are really quick to make up their minds and then are closed to being able to revise that, that's going to be a problem. That is going to structurally favor the state. It's going to make it that much harder for them to give my perspective a fair shake. So those are usually the main things that I'm looking for. Just, do I connect with this person on a communication level? And is this person generally open? Is this somebody that is going to reach a quick judgment and stick with it? Or is this somebody that is going to remain flexible and be willing to withhold judgment until time goes on and more evidence is in? And so, I typically get there with just general types of, scenario sorts of questions. I'll try to think up a situation where, maybe you had to change your mind. Maybe you got new information. Maybe you, took a quick decision about something. If there's been like a high profile case in the news, or like some recent news event, those are always kind of good segues into those types of conversations, the way that people judge information and evaluate it and process it over time. So I'll typically mine current events for things like that can be helpful. That's just my strategy.
How much I've noticed this with the newest batch of prosecutors we got in, they are really keen on eye contact. And in Denmark, we don't look you in the eye. It's not because we just don't like you. That's why we don't do it. Yeah, but
because Denmark's just a bunch of autists.
No, it's because we get a hankering to pull up an axe and make a longboat and go raiding when people look us too long in the eyes. We're like lions. But they have this where they're just standing there, and you feel you get into a tug of war with them. So you're sitting there, but do you try and read them, see if they want to keep eye contact with you, and because you can kind of see if they're just.
Yeah, I mean, I try not to read too much into body language, just because it can be misinterpreted. But at the same time, it is a whole nonverbal communication, is a whole aspect of how we relate to each other. And so if there is if I'm getting a real bad feeling about somebody, I will typically trust that. Something with like eye contact, it would just depend on the situation. Somebody who maintains eye contact with me could be doing so because they trust me. Somebody could be maintaining eye contact with me because they're challenging me and it's being aggressive, So you just have to take it as one piece of information, along with everything else that you're just using to gauge, can I form a relationship with this jury? Can we bond and connect?
But Again, everyone has different. That's why I love these body language channels. I watched them on the stand for 2 minutes, and you could see she was lying because she had a twitch in her right eye.
Yeah.
Can the defense ask after every witness, do you think your testimony proves that John was hit by a vehicle? They have to get that across. That wouldn't be the best
Yeah, I probably wouldn't do that. I mean, for one thing, they probably can't. It's improper to ask that question because the witnesses, what you're getting at is the witness think that Karen's guilty, and you're really not allowed to give your opinion about that. If it's something that you have, direct knowledge of, that's what you're allowed to testify to. If you're an expert and you have special knowledge, you get to go a little bit further and state your opinions. But by and large, most of us don't get to state our opinions. And even if we do, we don't get to give an opinion about whether we think the defendant is guilty or not. So I think that question would be skating a little bit close to the line on impropriety. But also I think it's kind of, it defeats the purpose. The best type of lawyering is the show don't tell lawyering. Don't tell them, what the issue is. You demonstrate to them. You don't have to ask the witness if the testimony proves Karen was hit by a car. Show the jury that it doesn't. And that will be much, much more effective, because then they're reaching that decision on their own instead of you expecting to persuade them by, beating them down with people saying it.
And we're almost done. How can they pick a jury in this second trial with all the publicity? So polarized, it seems.
Yeah, it's going to be interesting to see how much, if at all, the reach has spread. It's always a little bit difficult with high profile local things in small communities to get jurors that are clean slates. It's not impossible, but it can be a challenge. And there is also kind of the advantage that, we tend, like those of us who do legal commentary and are into true crime and into courts and things like that, we do tend to maybe overestimate the extent that other people are also interested in that.
Yeah.
There really are plenty of people that don't care about court cases and what's going on and stuff like that. But just with the way that this has exploded and how it's also crossed over into so many other areas with the whole, the Trooper Proctor, the misconduct investigation, the overlap with the Sandra Birchmore, all of that stuff that has evolved and developed since the first trial. It really does just raise a question about is it even going to be feasible to get people who are blank slates on this?
Yeah, 600 the first time. The jury pool in that town can't be exhausted by that. But funny thing, my daughter doesn't watch my channel. She's like, are you a YouTuber? Why? And then after she had the Baby Baker, one day she was like, "Oh, Baby Baker really likes your intro music." I was like, "You watch my channel?" "Yeah, I was watching this. That Karen Reed case is weird." And never had an opinion about it, and she's just that. And that's the thing. I don't know if you've seen, is her name McKinley or whatever, who's on TikTok, who started watching it like this week, and
she's
yeah, she's amazing.
She's a lot of fun.
I like it. I like it a lot.
Yeah, and it's just anyone who looks at it, unless you hate Aiden Turtle Boy, are seeing that there's so many problems. You have to be either related to the McAlberts or hate Aiden to sit there and say, nope, totally cromulent. Lynn says, my gosh, Andrea is an amazing speaker. Well, she earns her money speaking and reading the law.
I would imagine, though, that this time around it's going to be so much harder, right? Because the circus that was outside of the courtroom the entire 3 months or whatever it was, like it's not a big area, right? Canton's, Stoughton, it's not a whole lot of space involved here. Like I feel like this is going to be a much tougher jury selection.
Yeah, I do wonder, like, because that was, you would just assume, like, okay, people were aware that something really big was happening at the courthouse. Right. There's a lot of action, people out. I think the question is going to be, do they connect that with this retrial? Like, is there like folks who know what was going on before might make that connection with, oh, here we are back, and that whole scene was going on last time. But people who weren't necessarily that focused on the last proceeding just may not make that connection. So I think you just cross your fingers and hope for the best, that there are at least some people that either are oblivious about it, or even if they aren't oblivious about it, are going to be willing to not prejudge it.
Can Beto represent Aiden in court? Yeah, because he can't represent Karen Reed, so there shouldn't be any problems.
Yeah,
with
I believe
that.
he is
Still
representing
representing.
Aiden in court,
Yeah.
and that's the problem. That's why Judge Canoni said he can't also represent Karen. She thinks there's a conflict there, but she didn't tell us exactly what the nature of the problem is, which I think is a big issue on appeal.
Yeah, I would like to know what her and Brennan have discussed as far as Aiden being a potential, or Bettero being a potential conflict with Aiden. I'd like to see if those two have had any communications about the matter.
Well,
Yeah. course,
probably because they
they're
put
not
him on the
supposed to.
witness list and will try and imply that, well, he might need to take the fifth, plead the fifth, and so he might need his lawyer, which would go against Karen Reed, and that's probably something like that. But do you
It's possible.
think?
It's just that usually stuff like that can be managed. You can manage stuff like that. You number one, you just have a firewall between any information that Mr. Bettero has access to as a result of representing Turtle Boy and all the other attorneys in the case. They just never have access to that. So that protects the confidential information. Then if you get into a situation where you have a potential loyalty problem, he's up on the stand, you got to cross-examine him, you just have one of the other lawyers on the team do it. He doesn't have to be the one that's doing it. So, I've practiced most of my career in a small community. We run into potential conflicts of interest all the time because there's just only so many lawyers, and a lot of the people that go through the criminal system are repeat offenders. They're related to each other. The same people who are victimizing are also victimized by the crime. So you just get the same people in all kinds of different contexts and stuff. So we're pretty comfortable managing these types of conflicts and have to do that pretty routinely. There's nothing about this that I've seen, and certainly nothing that's in the record that we have that an appeals court would be looking at that makes it clear to me why this is not a waivable conflict and why this isn't something that they could just manage through ordinary management practices.
What do you think of all of Hanky Panky's misrepresentations?
He lacks credibility. And so the thing is that even if the court doesn't punish him for that, even if the court doesn't hold him account, the jury has to be able to trust you. And so if the jury sees, if he keeps this habit going of asserting things that he can't back up or misrepresenting things that we can see with our own eyes, you run the risk that you lose the jury's trust. And if you lose the jury's trust, it makes it a lot harder for them to vote for you. So I think it's a terrible strategy for a lawyer. You really need to be, rigidly honest in your representations. That's all you have to work with is people's trust in your word. So I think it's unwise, and we'll see how it plays out.
That's something that Brennan is lacking severely.
Mm-hmm.
He seems to be lying almost every time he gets behind the podium on some level or another.
Well, I've previously called this trial one of the gaslighting trials of the century. I mean, it was just a constant flood of people telling us things that we can like Trooper Buchanan, going through the surveillance video, counting the drinks that we can watch with our own eyes and see no, that didn't happen. You're literally lying to my face and expecting me to just go along with you when I can see for myself that what you're saying is not true. That has been, kind of part of the strategy. And maybe that worked a little bit in part because, Mr. Lally didn't do a great job of keeping us real alert to that type of testimony. We would get in that Lally lull in the afternoon. And so it was maybe easier to pull the wool over our eyes a little bit. Maybe that won't be the case so much this time. I don't know.
And I just get him. He's a defense lawyer, and he can't put that aside because the way he attacked Dr. Russell is how a defense lawyer attacks a state witness.
I would take issue with that. I don't think it has anything to do with what side you're on. It's just it's just your effectiveness as a lawyer. I mean, there's plenty of prosecutors that are, snide and aggressive and rude and unfounded. Self-righteous is just a very common, unpleasant trait to have to deal with in prosecuting attorneys. So I don't know that it's necessarily a defense thing that he does. It's just a strategy that for whatever reason he's adopted, because he thinks that's how you win. He thinks you win by tricking people instead of by, demonstrating to them through the facts and applying that to the law that he's
to argue that.
case.
I would say that when the facts don't have your back, you have to trick them. You know what I mean? If the facts aren't going to lay out innocence or guilt, then you have to trick them to get the verdict you want.
I mean, that's the strategy of somebody that lacks integrity. It is my answer to that would be every single case has bad facts, and you always have to figure out how to deal with bad facts. If you can't figure out a theory of your case that accounts for the bad facts, then number one, you should really be trying to convince your client not to take the case to trial, because the odds aren't going to be in his favor. But it's always the client's decision. If they insist and they want to go forward, sometimes the only thing you can really do to keep your credibility with the jury is just, ladies and gentlemen of the jury, I would ask you to please hold the state to its burden of proof when you're thinking about whether they've established all the elements of the crime, and you sit your butt down.
It's the 2-second opening and the 3-second close where it's just don't be too hard on him. There's some defense lawyers. I was covering a case where they just said, the judge had just said hello, and I was ready to call the jury, so they were on the record. And then he stood up and said, "I'm so sorry I did it," to his family. Yeah, that's kind of a problem. The defense lawyer was really not asking a lot of questions after that one. Because, the court said, the prosecutor said, "Oh, was the recording on?" Because court was set. Yeah, court was set.
It's just it's a misapprehension of what your job is on both party sides. Your job isn't to win. Your job is not to win. Your job is to
find the truth.
It's to make the best case that you can for the prosecution. It's to it's to meet your burden of proof. It's to present the evidence that proves that you've charged the right crime and you've charged the right person, and you've got the goods, the receipts to back it up. For the defense attorney, it's making sure that that they've done all those things. I've said many times to clients, I am a lawyer. I am not a magician. Okay. I can't change what people testify to at trial. I can't change what the jury is going to think about any of that. All I can do is just give you my best advice about what I think is likely to happen, given what we know about what the evidence is going to be. And so, no, not every case is a winner. And that's the way it's kind of supposed to be.
Yeah, because there are idiots out there who does a lot of bad stuff, and they will get caught sometimes. And as Eric says, I dislike Turtle Boy a lot, but facts are facts. Yeah, and that's the thing. I don't get, because I've said it from the beginning when they started. Well, you're just a mouthpiece for Turtle Boy. I said I've talked to him twice.
Right? He won't even return my DMs. That son of a gun.
That's just one of those. And thank you for helping me with the Grift, Jam Cracker, and Danny T. I'm about to round this off because we're getting close to 3 a.m. in the morning. And McCrae says, Andrea, is this worse than Johnny Depp? It's a different type of case.
Yeah. In what respect? I mean, in terms of a hoax, it's I would say that they are much cleverer than Amber Heard at being able to cover their tracks. They have a lot of assistance. Amber had a couple folks, but just, so many of her allies didn't really help her. They kind of helped undermine her case. They didn't see the right injury at the right time, couldn't substantiate anything that she said to him, things like that. So I think in that sense, like this is a better hoax. Jen McCabe is a much better witness than Amber Heard. Like they have very similar slipperiness, being able to pin them down from my perspective, very similar dislikability. Like they are not likable people. But Jen was much cleverer about not giving away the game in her own testimony than Amber Heard was.
And of course, in memory of that case, I bought a bottle of that. Just because I needed to see if her testimony. When I saw this bottle, I knew, ain't no way, girl, ain't no way you didn't go to the doctor the next day.
No.
I didn't realize what you grabbed that for first. Now I found that quite humorous.
How far would a prosecutor's misrepresentation have to go for mistrial or overturning on appeal? Well,
this is just a major it depends question. It depends on if you're talking about because it's sanctionable, in which case it's in the discretion of the trial judge, and it's unlikely that the Court of Appeals is going to overrule that discretion. If it's not so much about sanctions, but about its impact on the trial, it's going to depend on things like, were there corrective instructions given to the jury? The Court of Appeals always wants to take a no harm, no foul type of approach to errors. And so if there's a way to fix it, or an argument that it was fixed in some way, or that just even if it was bad, it didn't necessarily, cause catastrophic consequences, then they're just much more inclined to overlook it. So yeah, reality is it's very, very difficult to get things overturned based on a prosecutor's misrepresentations. I'll give you an example. Really common situation that comes up when you get into the prosecutor's closing. They'll say all kinds of stuff that didn't happen, right? They'll make these they'll like argue based on facts that there's no evidence for, or they'll bring in things that, weren't testified to, aren't part of the record and stuff like that. You would think like you're crossing the line, you're poisoning the jury. This should be maybe like an automatic mistrial or something. The defense basically gets put in an impossible situation. First off, if they don't object to any of this stuff, it's typically considered waived. Like you can't go to the appellate court and then say this was a problem. Or it's subject to like some really, really high standard of showing, really significant impact on the fairness of the trial, the ultimate outcome. If you do object, then the judge will just, best case scenario, turn to the jury and say, disregard that. Well, you can't unring the bell, but we have this legal fiction in appellate world that telling the jury, never mind, means it'll erase it. Yeah, it'll erase it from their memory, and it won't have any effect on how they perceive the case and their decision making and so forth. So the reality is, prosecutors misrepresenting things, I'd love to tell you that never happens. It happens all the time, and there's almost never consequences for it.
And to be fair, you had AJ was really good at ringing the bell constantly as well. Mm-hmm. Disregard that, and he just kept on. So it's one of those tricks that gets played now and again. But it's just because we've seen so much BS, and we don't know if he's going to try and put that in front of the jury as well. Hopefully not, but we never know.
I'm sure he will.
And Jason Sorensen says, come on, Baker, Bev isn't going to turn on Brennan. I know.
Never.
And the last things I have to do before I go to bed is saying thanks for becoming a member again, Lefty. And thank you, Marissa, for gifting 5 memberships, and Jamcracker for 5 memberships. Now I have paid all my dues to all the people who paid me. And let's see if there's any good questions to...
I just saw a comment fly by that I would love to see Jen Alessi or see Alessi cross Jen McCabe, and I am so on board with this comment. I also want to see this because Mr. Alessi, the detail man who's going to remember everything she said in every prior context, who she said it to, every excuse she's given, every time she's changed her story. He's the one to just be able to sit down and systematically nail her over and over and over and over and over again with impeachment material.
And he's absolutely fearless. He's not going to hold back for Jen McCabe. You know what I mean?
Yeah.
He's gonna go after her. Oh my God, it's going to be good.
My biggest wish for trial 2 is get better tech people. And I know Alessi will probably help them get better.
I'm sure.
I didn't understand anything about the phone. And I watch Cellbrite a lot. So I know how to sit and read Cellbrite at the dates and who sent it to whom. And I didn't understand one word. I really think they need either a better witness or a better question it, because I feel that that's one of those things that'll razzle dazzle the jury if they are going to talk about third party culprit.
Yeah, I agree.
Thank you. Andrea is inspirational. Oh my.
Aw,
That's
thank you.
I'm just an expert in strawman and unintelligent. That's what I get called.
I've said this since the first time that we saw Brennan. He is a man that I would never put in a position of authority.
Yeah.
He doesn't have the integrity to maintain a high level of success. He's going to eventually crash and burn, I feel, and hopefully that'll happen before Karen Reed gets thrown in jail in the process.
Yeah, well said.
Hopefully.
Don't forget to thank the replay crew. Well, I can't thank
Thanks,
them because
replay
they're
crew.
not here. But thank you all, the replay crew. No, most of all, thank you, Andrea. So nice to
Absolutely.
get to hang out with
My
you
pleasure.
again.
Thanks so much for having me.
Always a blast.
Always fun to get to talk to you. I normally always give people a little solo time to. Again, we are
Grifters.
It's a great shirt. Oh
It's
gosh,
good.
my grift. What's my grift right now? I would say right now the thing to look out for is my Substack. I plan on hitting publish tonight on a piece that I'm writing up about the pending process that's going on in the Federal Court of Appeals with Karen's habeas petition. A lot of people want to know, does this have the potential that the federal court could come in and stay the trial and stop it from going forward? I have previously taken a very strong, no, it's not going to happen position on this, but then we got the memorandum decision on the habeas ruling, and having read through that, I'm going to moderate that quite a bit. I still think it's not likely, but she's got a much, much stronger position than I had given her credit for before. So I'm going to be writing out about that and the possibility of that coming to fruition. I will be streaming the hearings next week, Tuesday and Wednesday. All of these motions in limine and everything else that's still hanging out there. In theory, we're going to have these all wrapped up in the next week before we go forward to starting trial on April the 1st. So feel free to join me on my channel then, Tuesday and Wednesday for those. And that's about all I got on the radar in the short term. Still catching up on Koberger. That's my kind of big other case that I'm following right now. So keep an eye on the Substack and also on YouTube. And likely I will have some stuff out about that soon.
Outstanding. Outstanding. You're muted. Yes,
it's because
I wasn't the only one that did it.
No, it's because I always muted when I put the other on big screen, so I don't sit here and say, I'll allow it. Like some other people know. But no, I'm tired. I had a good question that I lost. Well, remember to redirect.
What's going on, y'all? I already set up my redirect. As soon as we get out of here, we're going back on Baby Goat Watch. So I'm going to set up that live stream as soon as we leave here. We are waiting on a baby to be born. Yesterday morning, Mama was showing signs of early labor, so we stuck her in a stall with a camera on her, and now she hasn't done anything. So we're waiting for excitement to happen, and by George, I'm going to get it on camera. Let's go, Catalina. Let's go.
Catalina. The Catalina wine mixer, the
She's
biggest
a really pretty goat.
of the year.
She's a really pretty
Well,
goat.
Great
Catalina
movie
wine mixer.
We can't sing the song, but we can say thank you so much, Andrea. Thank you so much, all of you who stayed up from Europe to watch this. And I hope that you will all come back when we cover more of this stuff. I'm just going to put Andrea's as the pinned channel in top. Tomorrow I will be covering the snowplow pew-pewing again. Weird case. A guy who put 6 holes in another person and then claimed self-defense. Not sure it's going to swing, especially because the last 5 was when he was on his knees with his back turned. Sometimes people see they'll frown upon that. But have a great night, y'all, because I'm gonna go to bed now and try and find some of the sleep I normally try and get on the weekends. Love y'all. See y'all.
What exhibit are you referring to?
I'm going to make this 100, Your Honor.
All right.
100.
100.
Because it is 100%
100%.
correct.
Objection, Your Honor.
So you literally built a cannon?
Yeah, it's pretty awesome.
All right, I'm in love.
Go back. Please do that again. Oh, that was the cutest thing I've ever seen.
While I'm waiting for this, did you, whether it's true or not, believe that Mr. Randolph had slept with your wife?
I wouldn't care.
You wouldn't have cared?
No,
Did you believe he had slept with your wife?
no,
Did you believe he slept with your mother-in-law?
probably did. Everybody has.
So there-
Everybody has.